Hey y'all. Okay, y'all ready for part six? Okay, so now I am a public defender, and I was a public defender for 3 years. So when I started in the public defender's office, they started me with low level crimes, misdemeanors. So crimes like battery, petty theft, people stealing from Walmart type situations, DUIs, prostitution charges, driving on suspended license, and everything in between. Okay. So that's where I started when I first got there. By the time I was leaving, 3 years later, I was representing clients in attempted murders and DUI manslaughters and trafficking and drugs and all types of high level offenses. All right. So that was my range for the 3 years that I was there. So once I got into the system, I realized it's not what I thought it was going to be. This is a system that pushes plea agreements. Okay. What that means is if you have been charged with having committed a crime, the prosecutor will offer you an agreement to resolve the case. We call that a plea agreement. And that may be something simple like you have a battery charge, you can accept this plea agreement of probation. Honor all of the conditions of probation, and that'll resolve the charge for you as long as you don't violate, right? That is called a plea agreement. But on the other end of that, it would be if you don't accept this plea agreement and you decide to go to trial, if you lose, we're going to ask the judge to put you in jail for 90 days, right? Most people, most public defender clients are living paycheck to paycheck. They can't afford to go to jail for 5 days, let alone 90 days. So the consequences of going to trial are so steep that people end up going with the plea agreements. All right. And that is the nature and the culture of criminal defense. A lot of plea agreements and bargaining and negotiations, trying to reduce charges and sentences. But occasionally you will have the trial that is, or a client that's dead set on going to trial. So the average trial criminal defense, and this was 25 years ago, in our office, people would go to trial. The defense attorneys, prosecutors are in trial all the time, but public defender maybe 4 times a year. Okay, that would be the average. That wasn't the case for me, and I'll tell you about that later. So, because it so heavily pushes plea agreements and people are afraid to go to trial, they would rather take a plea and it get some innocent people caught up in that net. They end up pleading because they're afraid of the consequences of going to trial. All right. So this is what a scenario could look like. Let's say I'm going to give you a hypothetical. Okay. Let's say your son, your 18-year-old son, tells you he's going to spend the night at his friend's house. His friend comes to pick him up and he's gone for the night. So you know he's going to be staying overnight at his friend's house. What you don't know is that your son took your spare keys to your car. All right. You didn't know it, but he's gone at some point in the middle of the night, because your son knows when you go to sleep, he comes back to the house and he takes your car because he has his spare keys and he goes joyriding. All right. Let's just say you happen to wake up and you realize your car is gone. Now, you don't know that your son has your car. You call the police, you file a police report, someone has stolen your car. When the police come to your house, they're going to ask you, did you give anyone permission to take your car? And you say no. They'll ask you, does anyone else have keys to the car? You're going to say no because you don't know what's happening, right? And then let's say, so now they're going to do an investigation for your stolen car. And let's say the same night, all of this is a hypothetical, the same night, the police see your car, your son is driving it, and then they put on their sirens to stop. And let's say your son speeds off, okay, because he doesn't want to get caught. But then maybe a few seconds later, 10 seconds later, he pulls over. All right. And then the police officer gets out of the car. And let's say because your son is so nervous, he jumps out of the car and accidentally hits the police officer with the car door. That's the whole scenario. That's it. All right. What happens to your son will vary depending on the police officer that stopped him, the prosecutor that sees the case at intake, The prosecutor that eventually gets the case to litigate the case. It depends on the courtroom that he's in. It depends on the county he's in. It depends on the circuit he's in. It depends on the state that he's in. What will happen in that scenario will vary even in the same courthouse. All right. So I'm going to give you another hypothetical of how this situation could play out. Let's say courtroom one. All right. Courtroom one, they charge, well, let's say the police finds out, oh, this is your son. All right. And he took your keys and he, whatever. Okay. He was joyriding. Courtroom one will say he's charged with an unauthorized possession of a motor vehicle and he's given a speeding ticket. All right. So in courtroom one, they're going to offer him probation to resolve the charge. That's courtroom one. Let's say he gets on probation and then, now he's in trouble with you. All right. Over what he did. You punish him for life. All right. That's courtroom one. That's a great scenario. All right. But then you have courtroom two. And this could be courtroom two in the same courthouse. So in this courtroom, he is charged with unauthorized possession of a motor vehicle. He's charged with grand theft of an automobile. He's charged with burglary of an automobile. And now he's charged with fleeing to elude a police officer, which is a felony. All of this is felonies, right? In courtroom two, they want him to do some jail time. Your 18-year-old son who went joyriding in your car, they want him to do some jail time. So the offer may be, I don't know, 6 months in the county jail followed by 3 years probation. Same scenario. All right. Courtroom three, this is aggressive, really aggressive prosecution in courtroom three. And there's going to be some overcharging, what we call overcharging. That is stacking a lot of charges. It's kind of what you saw in courtroom two. Stacking a lot of charges, throwing a lot of charges against the wall to see what sticks. It's the stacking of multiple charges for one incident. In courtroom three, he is charged with unauthorized use of a motor vehicle. He's charged with grand theft of an automobile. He's charged with burglary. He's charged with fleeing to elude a police officer. In this one, he's going to be charged with battery of a law enforcement officer because he hit the police officer with the car door. And he's going to be charged with resisting arrest with violence because he hit the police officer with the car door as he was getting out. 6 charges. This is overcharging and stacking of charges. This is aggressive, really, really aggressive prosecution. In this courtroom, the offer is 2 years in prison. And if he doesn't like it and he wants to go to trial and he loses, the prosecutor may say, we're going to ask the judge to give him 5 years in prison. Same scenario. Totally different outcomes depending on the judge, the police officers, the prosecutor, city, state, county. Okay? This is what it really looks like in a criminal prosecution. And once I got into felonies, which was a year after I started, I was in courtroom 3. I was in the courtroom with the very aggressive prosecution, the stacking of the charges. I was in that courtroom where the plea agreement was so outrageous that we didn't have a choice but to go to trial. So whereas in a regular criminal defense attorney situation, you would go to trial 4 times a year, in the 3 years that I worked at the public defender's office, I went to trial 29 times. The plea agreements were so wild and so excessive, in my opinion. I felt like I'd rather take a chance with the jury. I felt like my clients would rather take a chance with the jury, and we did. And fortunately, it turned out the way that I wanted it to turn out. Thank you, Lord. But let me tell you what that looks like in a real life situation. You know what Sean Combs is going through right now, right? With his federal charges. I'm talking about Diddy. If you don't know his real name. They threw a lot of charges up against the wall in that federal prosecution. They charged him with statutes that they'd never used in a case like his before. They were doing some brand new things trying to pin him to the wall. They threw everything against the wall. And then when it all panned out, he was only found guilty of the two low level offenses. Now, had they offered him the two low level offenses like they would have done in courtroom one, he probably would have gotten probation and a few months in the county jail and been able to move on with his life. But because it was such aggressive prosecution, the plea agreement for him in the overcharges, the tacking on of charges, his plea agreement was 25 years in prison. That's what they were offering him to resolve the case. So he didn't have a choice but to go to trial because of the excessive and aggressive prosecution. And as it turned out, he only ended up with 4 years in prison. So that is a real life scenario. That is what it looks like in a criminal courtroom. And I happen to be in courtroom 3. And I went to trial all the time. So having 29 trials in 3 years is absurd as a criminal defense attorney. But in order to defend my clients and to defend their rights, that's what was required of me. So now here is what I want to tell you. I hated being in courtroom 3. I would have preferred, as a new young lawyer learning how to practice, to be in courtroom 1. Unauthorized possession of a motor vehicle and a speeding ticket. That's what I would have preferred. However, I learned how to practice law in courtroom 3 because that's where the fighting was. That's where I learned that the iron sharpening the iron and all of those things. We were in war in courtroom 3, and it was a constant battle. And I learned how to be a litigator in courtroom 3. So this is what I want to tell you. Do not be afraid of courtroom 3, because in courtroom 3, that's where you will learn to be who it is that God intended for you to be. Now, I don't know what your courtroom 3 is. It could be that they want you to be a supervisor in your job. And you don't want to be a supervisor because they're chaotic and unorganized, and the supervisors are fired first. So you're going to coast in the position that you're in. You're supposed to be a supervisor. You're supposed to learn how to navigate that field and learn how to fight in that arena so that you could ultimately end up getting the job that you're supposed to have and being who God wanted you to be. Your courtroom 3 could be going back to school. You don't want to go back. It's a sacrifice. Guess what? A sacrifice is required in order for you to get to the next level. It has to happen. Your courtroom 3 could be getting out of that relationship that you know you're not supposed to be in. You know you're not supposed to be in that relationship. It's time for you to make the hard decision, to do the hard thing. Do not be afraid of courtroom 3, because it is in courtroom 3 that you learn and you grow and you develop to be the person who God intended for you to be. Do not be afraid of the fight. That's why we're here. That is my story for the Public Defender's Office. I may tell you about the time that I saw R. Kelly when he came in for first appearance, because he got arrested in Polk County for the same charges that he had in Chicago 25 years ago, the child related charges. You know what I'm talking about. I may tell you about that one. I'm not sure. But anyway, that's part 6.